Thank you very much. Again, my name is Brian Tuttle, and just a quick overview. I've been doing HIPAA compliance consulting for all intents and purposes since 2003 when the HIPAA security rule came out. I've worked on behalf of the federal government as a contracted auditor, so I've sort of seen things from both sides. And anytime I talk about this, I talk about it from not only the perspective of the covered entity or the business, but also from the perspective of federal auditors and what they're actually looking for, trying to spell a little bit of myth versus reality with this. Obviously, there's been an enormous amount of change, especially since 2013 when this Omnibus Rule came out. Basically, the law is being enforced, a law that has for many years pretty much been kind of laying under the weeds, if you will, is now they're going full bore with enforcement. And there's several concerns with the changes, first and foremost being individual remedy, individuals learning they can sue under state law for HIPAA violations, which is being encouraged by the federal government of the states. So that's causing a great increase in the amount of complaints being filed with Health and Human Services, because that's the first step an individual would do for right of remedy under state law, therefore increasing more audits alongside the already going on proactive audits the federal government's doing. So needless to say, there are a lot of attorneys calling, both defendant, prosecution, needing assistance with either defense or prosecution of what's going on with a particular situation under this law. So without further ado, I will jump into this, and we've got quite a bit to cover, and there'll be about 10 minutes at the end for Q&A. Hopefully we'll end up finish this at about 80 minutes, and there'll be 10 minutes left for Q&A. So let's move on to the slide number 2. The Health Insurance Portability Act of 1996, just a little bit of history here to build up to where we are now. Law came out under Bill Clinton, and if you look at the name, Health Insurance Portability Act, it's interesting, but when you think of the word HIPAA, most of us think the same thing. You know, make sure and keep health information secured. Don't wrongfully disclose health information in any form, whether it be oral, whether it be paper or electronic. But there's a lot more to this law than just security and access to protected health information. It's basically about portability of your health insurance. That's what was the whole concept in the beginning, that you would have portability of insurance. You would have coverage if you left one job prior to picking up another job, so the federal government wouldn't have to foot the bill. That was the primary reason for the law in its inception. Obviously, there's been a lot of morphing and changing over the years, but it's funny, when we think of the word HIPAA, that's not exactly what we think of. We think of be quiet, don't wrongfully disclose health information. So next slide here, also known as the Kennedy-Kassebaum Act. It's not important to remember this, just a little interesting. It was bipartisan legislation written by these two senators and signed into law in 1996. And there were a lot of good things about the law when it came out, but the problem is the privacy and security aspects, which is interesting when we go to slide 4, the acronym. When you look at the acronym, Health Insurance Portability and Accountability Act. Then move to slide 5, and what's missing in the acronym is the words privacy and security. They're not even in the acronym, but by far they present our biggest challenge as a covered entity or a business. It's quite simple as to why it's such a big challenge. It's because the law is not written very well. A does not equal B. There's no silver bullet here. There's no perfection. It would be nice if we were told, okay, here's what you do and here's how to do it. We're told basically here's what you do, but not how to do it. So everything is subjective under HIPAA, at least HIPAA privacy and security. Everything's based on risk. It's based on reasonable and appropriate due diligence based on risk. Well, how do we quantify that? That's what makes it so difficult. Now, with that said, and I'm going to say this a lot, and this is very important, being proactive is the best defense that you can have with this law. And what I mean by that is being proactive in terms of getting your risk assessments done,